Good morning and welcome. It is Sunday, March 1st, if you can believe it, 2026. And this is Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Welcome, everybody, and happy March. Can you believe it? We're already into the third month of the year. It seems to have flown by. Hello, Little Miss Red Velvet and Shy Gal, Kathy Mama Bear, Ain't No Hollaback Girl, Joy W. Can, Best Nancy, Amy, Odell, Becky B. So good to see so many familiar names and faces. I'm so glad that you're here. If you're watching on X or if you're watching on Facebook, please don't be shy. Give us a little shout out. Say hello. Let us know where you're from. And to all of our new folks, welcome. If this is your first Sunday Funday, please say hello in the chat. I just am tickled by the idea that this might be your first experience with what is quickly becoming our favorite thing to do on this channel. And to those new folks, let me introduce myself. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for just over 10 years before I sadly decided to leave and go into private practice as a criminal defense attorney. We started this channel, Courtroom Confidential, with the idea, the concept, the mission statement, the goal of presenting to you both sides of the courtroom, both sides of the story, both sides of the issues, and we hope that we do that. And this is a show that we call Sunday Funday, where we have taken your questions that you've left us voice messages about throughout the week, and we're going to answer them live today. And we've got some really good ones. You guys have come through once again with fantastic, fantastic questions. So I appreciate you so much. Debbie Haro, look at you. You are so fantastic. Thank you so much for kicking us off this morning. Josh is so great. Never miss a replay or when he's giving his thoughts on other shows. Hello, beautiful Tiff and our great mods. If you haven't joined, please do. So much fun and knowledge. Debbie, I got to tell you, you are so fantastic, and I am so appreciative of your support. That is so very kind of you. Thank you so much for kicking us off this morning. Stay to the end. We do have some announcements. There's some stuff coming up, some fun things I don't want you to miss out on. What else do I got for you? That's it. Should we jump into this thing? Take a deep breath. Oh, it's Sunday. You made it through another week. It's the end of the week, beginning of the next, depending on how you look at it. Hit the like button if you haven't already. Subscribe if you haven't already. Share this with anybody that you think might enjoy it. And enjoy this ad-free live stream coming to you from Courtroom Confidential. Let's jump into these questions, shall we? Who is going to kick us off this week? Already. Get it together, Ritter. Here we go.
Hi, Josh and Courtroom Confidential. This is Kim calling in from Arizona. It's nice and chilly, and I'm going to ride this wave for as long as I can because I know the heat is coming. My question tonight is regarding judges and immunity. Can you explain to us just how extensive that immunity is, how it works? If say, and a case goes to an appeal and the appellate courts overturn it and say they find that the judge was completely out of line, misconduct, sorry, I'm not sure what exactly to call it. Is there literally zero repercussions for the judges of our judicial system? Thanks so much for your time. I love your channel. Being a member is one of the best things I've done. I appreciate all of your dedication. Have a great day.
Kim from Arizona. Let's put you on the map. What a great question. I got to tell you, Kim, this question sent me on a journey because I think it took about 3 different turns before I figured out what exactly it was you were asking. And it's a great question. So, Kim from Arizona, thank you so much for being a member. What you're asking, I thought you were asking about like how do they grant immunity and then what happens on appeal. But what you're talking about is the concept of judicial immunity. Yes, judges, like members of law enforcement, like prosecutors, enjoy a certain level of immunity for doing their job. What does that mean? Well, it's referred to as absolute immunity. Does that mean that they are immune from absolutely everything, as the name would imply? Yes, and kind of no. First of all, it's immunity from civil actions. In other words, a judge can't make a mistake on the bench, make an incorrect ruling, do something that's appealable, and that defendant turn around and say, well, your decision was in error and the appellate court decided it was in error and they turned around my conviction and I'm now a free person and you robbed me of several years of my life because of your bad, dumb decision. And therefore I'm going to sue you for all that time. Can't do that. So they enjoy immunity from that. And they enjoy immunity from nearly everything else because, and if you want to think about it, there is a public policy behind this. We want judges, we want prosecutors to be able to do their jobs without in the back of their mind thinking, am I going to get sued for this? Or am I going to go to jail for this? Now, where does that end? I can hear all of you saying, but wait a minute. Does that mean they get to do whatever the heck they want? No. There are, like everything in life, exceptions. One of those is, interestingly, lack of jurisdiction. So a judge cannot just sit on their bench in Orange County, California, and decide what the law should be and make some sort of decision in Ventura County, California. That would subject them to some sort of liability, because that would be them clearly acting outside of their own jurisdiction. Same thing too, judges can't just, sit on a criminal court bench and make trust and wills decision or estate matter decisions. They've got a limit to their own power. Try to tell a judge this and you might see an incredibly shocked look fall upon their face. But yes, there are limits to their power. Also, this only applies to acting as a judge. So non-judicial actions, DUIs, speeding tickets, murder are going to fall outside of their official judicial actions, and they're not going to enjoy immunity for that. So that includes things like criminal acts as well, including criminal acts on the bench. Does this ever happen? Yes, it does. Shockingly more often than you would think. And judges do get removed. They do get in trouble. They do get censured. But I'll tell you, getting a judge actually removed from the bench is incredibly difficult. There are a lot of bad judges. One of the lessons I learned very quickly after graduating law school and starting to actually practice as an attorney is how poor many of the judges are on the bench. It shocked you. You think to yourself that these people have to be all-knowing and wise and balanced and certainly up to date on the law, because they're wearing on the black robe and they're sitting higher than you in the courtroom. And then you quickly find out a lot of these people, how did they get this job? Then when you get to be older, like I am, many of your friends start becoming judges. And then it's just a comical experience to appear in front of someone that you're like, I know you, dude. I've seen you get drunk at a happy hour for a going away party. Don't try to tell me what the law is or isn't. I could have provided you with plenty of examples of judges that have been removed from the bench. One that came to mind immediately was a judge not too long ago was removed from the bench for there was a camera in the courtroom that caught the judge surfing the internet during a criminal murder trial. I think it was even for, shall we say, inappropriate content. That was what the judge was spending their time doing during that murder trial. But Kim, excellent question. I'm glad that you asked it. Thank you so much for kicking us off this morning. Kim from Arizona, everybody. All right. Let's move it along here. Where are we going? Here we go.
Hi, Josh. This is Maureen from Monterey. Thanks for answering my question about the difference between a law and a statute. Your explanations are always so good and helpful. I have another question about charging decisions. Some of them really baffle me. And this one question pertains to a YouTube video I saw about a woman named Sarah Safranek in Illinois who pleaded guilty to suffocating her 7-year-old son Nathaniel with a pillow. It's a very sad case. She had tried to suffocate him many times, and there was voluminous evidence of this, including recordings of Nathaniel recounting some of these instances. What baffles me about this case is that she was charged with second-degree murder. Why second degree? I think it was clearly first degree. And the other thing that really I don't understand is, if I'm remembering the video correctly, she was charged with 5 counts of murder. She murdered one person. I really don't understand this charging decision, but I know that your explanations are always so clear and they make the law so much more understandable to we non-law people. So thanks again, Josh.
No pressure. Thank you so much, Maureen from Monterey. I hope I can make this clear, because I'll be honest, you guys ask such great questions. A lot of times you're asking questions that even lawyers who've been doing this for a long time don't quite have their head wrapped around still. But excellent question. I'm not familiar with the case that you're talking about. To the second part of your question as to why would somebody be charged with multiple counts for the same crime? You see this happen first of all, the way I should preface this is every jurisdiction is different. So they're all going to do things differently. Where I'm used to in California, if you killed one person, you're charged with 1 count of murder. If you killed 2 people, you're charged with 2 counts of murder. And then we try to figure out, what is the prosecution going to argue as far as degree? What is going to be instructed to the jury as far as degree? In other jurisdictions, you charge each degree. So you might charge a person for 1 murder with first degree, second degree, manslaughter, involuntary, and it may look like they're getting all these different charges when in fact it's only 1 crime. But the way that they work in their jurisdiction is that the prosecution has to lay out all of those crimes before they go to trial, so that the person is well aware of everything that they could possibly be exposed to. Like I said, different for each jurisdiction, also different on how they treat degrees of murder. First degree murder is not necessarily the same in every jurisdiction. Second degree, same thing. Some jurisdictions have third degree murder. I've never dealt with that. In California, we have first degree, second degree, voluntary manslaughter, involuntary manslaughter. But the way that we define those are even different from jurisdiction to jurisdiction. But for the most part, I'm going to try to give you a general understanding. The best way I think to think about this is to start with second degree murder. Second degree murder is kind of your baseline, okay? It is murder with malice aforethought, meaning that some sort of intent was involved, some sort of conscious intent was involved in committing this crime. Malice aforethought can be either express or implied. Expressed is like intentional, through either their own words or their own actions, an obvious expressed intent to kill, okay? Or it can be implied by what we call conscious disregard. So somebody does something that is so inherently dangerous, but that crime itself might not be the commission of the murder. The example is throwing rocks off of an freeway overpass. You're throwing huge stones at people's cars. The act you're committing is the throwing of the stones, but doesn't that involve a conscious disregard for human life? And shouldn't we charge with murder if somebody ends up dead? Okay, so that's second degree murder. Malice aforethought, either express or implied. To get to first degree murder, then you got to aggravate up. You need something to enhance that, is the way I like to think about it. I hope this is making it clear. So how do we aggravate up? Well, we add an element of premeditation, meaning some sort of specific intent to kill that is accompanied by planning and deliberation. To your point of the example you gave, if somebody had been trying it more than once, if they have been planning it in advance, if they had been talking to people about it, if their search history reveals that they've been looking into this, i.e., perhaps a Kouri Richins, if she had attempted to take his life before. Compare this to perhaps a Brian Walsh, where there was really not evidence of him planning it before. Not to get into a debate about those cases all over again, but these are examples of where you might see a difference between second degree and first degree murder. Another way you get to first degree murder is through felony murder, where a person is committing some other incredibly dangerous crime. armed robbery, residential burglary, the R word, things like this, and somebody ends up dead, we're going to say that that is enough aggravation to turn that second-degree murder into a first-degree murder. Okay. Then to go from second degree down, you have to find some sort of mitigating factor, something that makes it less than a second-degree murder. So for voluntary manslaughter, you might have heat of passion. We've decided that you cannot form the requisite malice aforethought for second-degree murder because you were so caught up in the heat of the moment that you lacked any time for reflection or a cooling down period, and you committed this crime. We're going to mitigate it down to a voluntary manslaughter, or even lower than that, involuntary manslaughter, where there is no element of intent, but you've done something that is criminal. Perhaps you committed a misdemeanor. Perhaps you committed a DUI. And in the midst of a DUI, somebody gets killed. Well, we're not going to say DUI is a felony. We're going to call it a misdemeanor, driving under the influence, but then somebody ends up dead. Therefore, you get charged with a vehicular manslaughter or an involuntary manslaughter. Hope that makes sense. Like I said, I'm giving to you kind of general rules, but it's mainly California. For instance, in New York, it's entirely different. New York, across the board, what we would consider first-degree murder is a second-degree murder unless there's an aggravating circumstance like terrorism or torture or something. But for the most part, it's all second-degree murder. Everything's different. So I guess what you can say is take everything I've told you and then forget it all, because it really depends on the jurisdiction. But that's kind of the general way that people understand it. Maureen from Monterey, thank you so much for asking the question. Annalie Finch, thank you so much for the super chats. That's a great way to start off a new month with Sunday Funday. Oh, we love having you here. Thank you for saying that. Best Nancy, thank you for the super chat. Says, I've missed Sunday Funday. Good to be back. Glad that you are back. Good to have you here. And Eroy, thank you so much for gifting the memberships. I appreciate that, and I hope everybody who receives one enjoys them. All right, let's keep it rolling here. Get it together, Ritter. Here we go.
Hi, Josh. Hi, Tiff. Hi, Mods. Hi, CC crew. It's Little Miss Red Velvet from Manchester. It's great to see you all. Although I have seen you on CC Live Trials, where we are having lots of fun watching the current trial. My question today is around the Anna Kepner case, which is the cruise ship, which is being tried in federal court, and it's under the FBI's jurisdiction. The stepbrother has now been charged with murder, but at the moment he's been charged as a juvenile. He is 16 years old. Why is that? And who makes a decision to charge as a juvenile or an adult? Because the other case of the 15-year-old girl who killed her mother, she was charged as an adult. There is a custody battle going on alongside. Do the parents have any culpability at all with regards to the medication that was forgotten with regards to the stepbrother, and also the supervision conditions on board the cruise ship? All the documents are sealed as well. Could you explain a bit about that? Look forward to seeing you on Sunday. Bye.
LMRV from Manchester, England. Thank you so much for calling in. Always great to hear from you. First of all, thank you so much for giving a shout out to Courtroom Confidential live trials. We have been streaming the Kouri Richins trial day to day, gavel to gavel, and it has been a fantastic group of people over there in the chat. If you're looking for some place to watch this trial, please check out Courtroom Confidential live trials. That's our sister channel. We'll put the link in the chat for you guys to subscribe to that so that you can watch it with all your CC crew members. Great question. Talking about Anna Kepner, really sad case. This is the young lady who was killed while on a cruise ship with her family. Now we're finding out it was her stepbrother. It's awful. He's a minor. I think he's 17, 16. A young person, but also getting close to that age where they would be considered an adult. So a lot of people are wondering, will he be charged as an adult? And you ask a bunch of other great questions. What about the fact that his meds were off? Who else carries responsibility? A lot of those things I think will be hashed out. I don't think we're going to see additional criminal charges, but a lot of those things might be hashed out in civil court. But as to the question of will he be charged as an adult, that is something yet to be determined. I don't believe last I checked, I don't believe they arrived at a decision on this thing. And it's difficult. I will say this. It is not an easy decision for these prosecutors to make. Because you got a lot of weighing to do. These are one of the situations that makes a prosecutor's job very difficult. It's easy to prosecute a hardened criminal who's committed several crimes of violence in the past, and now you're trying to put a very bad person away. That's the easy stuff. It's this stuff that becomes difficult, that you lose sleep at night. Do I charge this person as an adult or not? He's a young person, obviously very troubled, never committed a crime of violence in the past that we know of, obviously suffering from some sort of mental issues, perhaps medication played a role in all of that. All of these things are going through the decision-making matrix of the prosecutors and their entire team. And then on the other side, you have this horrible, horrible murder that a young person lost their life. For what reason, we don't know. Was the motivation for that a fight, or was it just, I know that there were people talking about that he may have developed feelings for her, I guess is the most sensitive way of putting that. But then also he strangled her to death. That's not an easy way to kill somebody. That takes time. That takes time in the matter of not seconds, but minutes, and several minutes, and minutes while that person's already unconscious, that you continue to strangle them before they actually die. So they're going to take into consideration the severity of the crime. They're going to take into consideration his age, his criminal history, his mental health, his maturity level. There's a wide difference between 17-year-olds, 16-year-olds, right? And probably the biggest factor is what we call amenability to rehabilitation. That's the way that they view juveniles. Is this a young person that we can save? Is this a young person whose brain has not fully developed and there's a way to put them back on the right path? Or is this a young person who needs to be treated as any other adult? And now we're talking about decades in prison. Not easy questions, not easy answers. Thank you so much, LMRV from Manchester, for asking the question. I'm sure we're going to be talking about that case for many weeks to come. Jerry Michael, thank you so much for the super chat. So generous of you. So why is the law so different from state to state? Great question. For the most part, it's not. I don't want to make it sound like it's drastically, different, that you can't even understand what's a crime from state to state. They all follow the same general rules. Exposure on different crimes is obviously going to be different. Some states have outlawed or decriminalized certain things, marijuana being the first thing that comes to mind, whereas other states have not. But they're different because each state is its own sovereignty. Each state can decide the elements of the crime. And the elements, while they all kind of follow these model elements, you can't go wildly, out of control, or the Supreme Court's going to shut you down. They are slightly different, and different enough that if you're going to practice in a different state, that's why you either need to pass the bar there or have somebody sitting along next to you so that you understand how these things work differently. But it's a great question. Thank you so much, Jerry, for asking it and for your generosity. Heather Cooper Smith, thank you for the super sticker. Always good to see you. And Crime Curious, thank you so much for gifting a membership. Appreciate you for that. All right. Where are we at here? Let's get it together. I'm going to figure this out. Here we go.
Hey, Josh, this is Court Lurker again, calling in from Spokane, Washington. I do have a second question. I totally get it if you can't get to it. I am curious. We all know that law enforcement can straight up lie in an investigation. And I'm curious if that includes to the media. Can they flat out tell you, no, we don't have this? Or, instead of saying we're not going to discuss that because of the integrity of the investigation, can they just flat out lie? And then when trial comes along, all the evidence comes out and we see, oh, that was the case, etc. So I'm just curious on, I would say, maybe the rules of engagement of law enforcement and media. Again, I appreciate everything that you do, all the time that you take out to answer all of our questions. Tiffany, you are just so sweet. The mods, wonderful. The community, the greatest. Just very awesome. And thank you so much. Happy Sunday Fun Day, everybody.
Court Lurker, thank you so much for that. Warming our hearts from Spokane, Washington. So kind of you. Appreciate all your support and for being here. If you're here this morning, please say hello. Great question. I love this. So yes, law enforcement is allowed to lie during interrogations. We've seen that before. It's a tactic. We say lie. It is a lie, but I think a better way of putting it is they're allowed to use deception is the way that law enforcement would put it. And I think that is the way to put it. I mean, here's the thing is it's all fair as long as they are following and respecting the constitutional rights of the person that they're interrogating. But yes, they are allowed to, walk in with a thick file full of blank paper and slam it on the desk and then refer to videotape and refer to other stuff. Does that push up against the line of coercion? It can. That can be problematic. That can also be decided by a judge down the line, and judges do. But they're allowed to use deception. Are they allowed to do the same with the media? I love this question. The answer is yeah, they are. But they got to be careful about it, right? There are instances where you could understand why they would. If they don't want to alert a suspect that they're zeroing in on that suspect, they can say things like, we've got nobody, we've got no leads, which is not entirely true, which is deceptive. You want to call that a lie or them being less than forthcoming, however you want to paint it. They could get, they're, in other words, there's no law preventing them from being deceptive with the media. And it would not affect the constitutional rights of the person if they eventually apprehend and put somebody on trial. They can't turn around and say my constitutional rights were violated because they were less than truthful with the media during this press conference. And I know that you had referenced in another question, like, what if they said that they had a piece of evidence, like a glove inside of a home, and deny having that when in fact they do have it? And that we don't know that to be the case in any situation that we're currently looking into, but could they do something like that? Yes, they could. I think the better way of handling it is always just to say no comment or can't comment at this time. But so why would they have to be careful with it? Because they need the media as their partners many times. Many times they're going to go to the media and say, we need you to get this message out. We're looking for this person. We're asking you to act as partners with us and helping us to solve this crime. Or they're asking media people, I'll tell you something, but don't release that right now. There needs to be a certain level of trust. And if you're burning the media by just lying to them, that's going to break down completely. And they're never going to trust you. And they're not going to protect your sources and respect your request to not reveal certain things or to only give information on background. Why would they ever want to break that down completely and flat out lie about something? So it's a delicate kind of balance as to furthering their investigation and at the same time maintaining credibility with the public and with the media. Great question, Court Lurker. Something I had not really put a lot of thought into, but I'm glad that you asked it. All right, let's keep it rolling.
Hello, Josh, and all of the Courtroom Confidential family. This is Lori Feeney. I'm calling from Bolivar, Ohio. And I have a question on the Kouri Richins case. The other day, the defense attorneys argued that they wanted to go directly from cross-examining the state's witnesses into their direct examination of that same witness. And of course, I believe that the state argued that that would break up the flow of their case. Maybe they did argue that, maybe they didn't. I can't recall. I might just thought that. But anyway, her argument back was, but then I'm going to have to lay foundation all over again, and those people aren't going to be allowed to be in the courtroom until they are called back, and so yada yada yada. The judge ultimately ruled that she could not go right into her direct after cross-examination. So I would like to know your opinion of that and how you would have ruled on it. Thanks so much, and everybody have a great day.
Lori from Bolivar, Ohio. Thank you so much for calling in. This is a great question. A lot of people actually had this question. So I know a few of you asked this. I'm going to try to answer all of your questions in this question. See, Southern CJB had the same question. This kind of, I know that this made the rounds on the internet as well. I saw these clips, people talking about this. Kathy Nestor threw a bit of a fit in court because the judge wasn't allowing her to handle things the way that she thought was the best way of handling it, that she thought was the most efficient use of courtroom time. Here's the skinny on this whole thing is the short answer is no. The short answer is the way it works is one of the sides calls their witness. Prosecution calls a prosecution witness. The prosecution asks questions on direct. That sets the scope of cross-examination. So if they're only asking about certain events, certain things, that is what you can cross-examine on. In some circumstances, the judge will allow you to get beyond the scope of direct. If the judge feels like it makes sense, furthering the conversation, getting the truth out, it's up to the judge, though. I mean, that's a common objection beyond the scope. Judge will say, granted, move on, defense. Sorry that you don't like this. The defense can, and I've seen it happen before too, say, Your Honor, this person's also on our witness list. Therefore, we would like to open up cross or take this person on direct at this point, up to the judge. Now, why would a judge allow that? A judge might allow that because he realizes that the issue that the defense really wants to get into is kind of a collateral issue that's not going to take a bunch of time, and there might be a saving of resources instead of having that person come back. A judge might deny it, though, for several reasons. One, I'm not going to allow you to cross-examine someone to get your points out there. If you want to do it, you're going to have to do it on direct. So that might be one thing. The judge might allow them to turn around and do a direct examination of that same witness. But I could certainly see a judge saying, I'll allow you to get into other topics beyond scope, but I'm not going to allow you to do it through cross, because we all know the difference in way you can ask questions on direct and cross are vastly different. And it's much easier to ask on cross than it is, because you can ask leading questions than you can ask on direct. But a judge also might deny it because, one, the prosecution is putting on their case, and they've got a way that they want this laid out, and they've got a theory that they want presented, and it's their time to do this. And if you want to rebut that, do that on defense. And who knows what's going to change between now and the time that you put on your case. So I'm not going to allow you to just kind of bulldoze your way in and say, I want to put on my case now. Calling witnesses out of order is a thing that sometimes happens. If a witness is not going to be available later on and the defense is saying, can we call this witness out of order now? That'll happen, fairly common. But I was okay with the judge denying this. No, I'm not going to let pardon. Wait a minute. It's going to inconvenience you to have to bring people back to court. You're going to have to reestablish foundation when you bring the, yeah, you're getting paid for all of this. Do your job. That's the way it works. We have this all laid out a certain way because it works a certain way and it makes sense and it's fair to everybody involved. And I'm not going to allow you. Good on the judge. Is this Mrazek? Good on him for saying no. I'm the one sitting up higher, wearing the black robe. I decide how my courtroom is run. And I thought she did a little bit of something that I hate when attorneys do, which is kind of toss around there. I've been doing this for this long. No other judge has said, you really want to piss off a judge? Start throwing around how other judges let me do such and such. Not a good look. She should have just let it go. She made a good point, by the way. Hey, for judicial efficiency, can I just call these people? Can I just continue my case here? The judge said no. And then you go, okay, thank you, Your Honor. Just a good idea. And if you want to talk crap about him behind his back, do it. But you don't start throwing around your weight in front of a judge, especially if you want to see a judge really dig their heels in. All right. Debbie, you are so fantastic. Thank you so much for all our great mods, coffee, tea, or something sweet. Tiff, you are the best thing for Josh, but also for us. I'll never stop shedding a tear at the end. Aw, always sending love and light. Keep Josh safe when he's traveling. You're very, very sweet. I appreciate that. That's very kind of you. Thank you, Debbie. Ms. J Vibes, thank you, says, piggybacking on the lying question, why is it that defense attorneys can leak half-truths or hire PR teams, but it's considered completely off limits for prosecutors? Well, first of all, they shouldn't be leaking half-truths. They shouldn't be doing that, especially if the judge has orders in place. They can hire PR firms for whatever they want. Prosecution, it's not like they're prevented from doing it. They just usually don't. And I think that's because they represent the people. They are the government. They are the establishment. And I think they should maintain some level of decorum and allow the facts to speak for themselves in a courtroom. But defense attorneys, if they can affect the public through some publicity, are going to take advantage of it for sure. But there isn't any like rules for either side. Thank you for that, Miss J Vibes. Great question. And True Crime in a Minute. Look at you. Thank you so much for the generosity. Josh, Tiff, and Kaylin, I'm drained from the first week of Kouri's trial. Thank you for all your content and insight. It's not easy, and you make it look easy. Oh, first round of juices on me. That's very sweet of you. That's very sweet of you. Thank you so much. And Sarcasm, thank you so much, says, isn't this usually one done for out-of-state and or expert witnesses from out-of-state? Usually done for, yes. That might be a reason why the judge would do it. Yeah, the judge would say, okay, listen, I get the problem and having this person travel again. We're going to try to accommodate their schedule. We're going to try to accommodate the costs. They'll do it too if people just say, hey, I'm available now, but if you try to get me in 2 weeks, I'm going to be out of the country. Here's the thing, though. It's well within the judge's discretion to say no. Sorry. There's not an appealable issue there for the judge to say no. If you got to pay for your witness to be flown out again, sorry, you got to pay for your witness to be flown out again. Judges, one of the biggest compelling motivations of judges, though, is courtroom efficiency. They want things to be moving along quickly. They've got this almost hardwired fear of wasting jurors' time. And if they can make things more efficient, they're usually going to do it. And that's usually a good argument. Like I said, she had a good argument. I just think she really rubbed the judge the wrong way from the way she handled being told no for the first time in her career. All right, let's keep it moving here. Where are we? Kaylin's going to yell at me.
Hi, Josh and CC crew. This is Dawn from Fairfax, Virginia. I'm watching the Kouri Richins trial on Thursday, and when they're talking to law enforcement, there seems to be a lot of I don't know, I don't recall answers to the questions. Are law enforcement not allowed to review their reports and body cam and notes from their investigation so they had better answers? Or is this a tactic they use? Just like to know so that I don't think, wow, shouldn't he know this? Thanks again. Happy Sunday Fun Day.
Dawn from Fairfax, Virginia. Thank you so much for asking the question. Good to hear from you. Talking about the Kouri Richins trial. Great question. Here's my thoughts on this. One, it's understandable that law enforcement would have problems remembering some of this. This case is years old, remember. I mean, this thing has been dragging on by the time we got to trial. So we're talking about events from years ago. They've handled many, many things in between, and I'm sure there's a lot of little details they're going to forget. To your question, yeah, they're allowed to and are encouraged to review their reports, any videotape, any evidence they're going to testify to, prior testimony. If they testified at the prelim, for sure. I always handed my cops their prior prelim testimony. That was probably the most important thing because that's what they've already put under oath before. Read that. I don't know how often they would, but I would tell them to read it before they testified. But I also tell every witness a perfectly acceptable answer is, I don't know, or I can't recall. Nothing wrong with that. As long as you're not being evasive and you're overusing it just to cause everybody grief. What that signals is I'm not willing to give you a guess, and I'm not willing to give you an answer that might be slightly wrong for you then to try to take advantage of it and say that I'm lying. I'm not going to give you an answer that might be just a little bit different from what I put in my report or from what I testified to at prelim for you to turn around and try to turn that into a prior inconsistent statement. So I'm going to say, I don't recall. And attorney, if you want to really get the truth out there, then go ahead and refresh my memory and say, can you take a look at the report? Because we all know what you want is a specific line out of the report or a specific line out of the testimony. So go ahead and refer me to that and I'll get that on the record. So sometimes it's the sign of a clever or experienced law enforcement officer, somebody who has in the past made the mistake of guessing using their best memory and not letting everybody in the room know that, instead of just saying, I don't recall. It's on the attorney. Happens all the time for the attorney to say, would it refresh your memory to take a look at your report? In fact, in cases that are really old, I've had the judge just allow them to have their report up there and refer to it freely. So Jolie says it's a bad look. It can be a bad look if they appear as though they have no idea what they're talking about. But it also can be, I appreciate it. I would say this. I would certainly appreciate it as the prosecution if the cop is doing that on cross with the defense attorney so that he's not going to let something out that the defense attorney is going to try to exploit as if he's lying or none of his memory can be trusted. Great question, though, Dawn from Fairfax. Appreciate you and appreciate you calling in. All right. Let's keep it rolling here. Jude the Tiger, thank you so much for gifting the memberships. Appreciate you, Jude. TLC Teresa, thank you so much for becoming a YouTube member. Welcome aboard. And Ann Potter, thank you so much for supporting the mods with coffees. Very kind of you, Ann. Keeping those mods awake. All right, here we go.
Hello, Mr. Ritter. My name is Becky. I'm in Des Moines, Washington, right outside Seattle. My YouTube name is Dom's Mom 725. And I just had a kind of a random question. I've been following the Kouri Richins trial. And it just seems like she has kind of a robust defense team for someone who didn't privately attain them. So I was a little confused. I can't remember where I heard it, but that they're not necessarily public defenders, but they were assigned to her maybe through a different um, area. I'm not sure. I was kind of confused by it, but I know she didn't privately retain them. So it just seems like she has what, like 3 or 4 of them. And usually in a public defender situation, I've not seen more than like 2. So I just wonder how she got such a big, robust defense team. So anyway, love your show. Love your Sunday fun days. They really are great, and they're my favorite one of the whole week. Whether I call in or not, I just love hearing everyone's questions and learn so much. And your coverage on the Guthrie case has been magnificent. Also glad to see you're back to reporting on other stuff as well. But anyway, I hope you're well and hope everyone in the courtroom confidential crew is well. And look forward to Sunday. Thanks.
Becky from Des Moines, Washington. Got that wrong one time before. Won't make that mistake again. Thank you so much for calling in. I hope that you are here this morning. Please say hello. Talking about the Kouri Richins trial again, Kathy Nestor. How I love this question because I'm asking the same thing. She's not paying for this. The taxpayers of Utah are paying for this. Why does she seem to have this A team of attorneys lined up for her? Is it because she's got a popular case? That doesn't seem to make a lot of sense. Do you think every publicly appointed attorney or publicly appointed defendant has got a team of attorneys like this on a murder case, or is it just Kouri Richins? Great question. Robust for sure. The answer is this. First of all, she is not a public defender. She is a private attorney, but she is court appointed to this case. So the way this works, some jurisdictions have a public attorney's office. Some have just a court appointed attorney system, and some have both. So in LA being as big as it is, they have the public defender's office, then they have the alternate public defender's office, and then they have the court appointed private attorney system. So why? Well, in situations where you maybe have multiple defendants and none of them can afford an attorney, this all comes down to the constitutional guarantee that you can have an attorney assigned to you. Through the Supreme Court said this is part of your constitutional guarantees. You can have an attorney provided to you if you can't afford one. So every jurisdiction has to come up with that. Even if they don't have the resources for a full-fledged public defender's office, they're going to figure out a way to do that. So in some of these smaller counties, what they do is that if you're a private attorney in that county, you got to sign up for this. It's part of being an attorney in that county is that you are occasionally going to get cases assigned to you that you have to work on for free, and you can't say no. Kathy Nestor is one of these attorneys that takes these cases routinely, though, and she's getting paid on whatever kind of fee basis from the state. She's also the attorney on Tyler Robinson. Same thing. She's appointed on that case. Now, does that mean that she can go back to the court and say, well, I'm not just myself, I'm a team, and I need these 3 or 4 other attorneys working on it and all of that? I don't know how that fee structure works. I'd be very interested to know. Are they all getting paid a fee? Is it one fee to her firm and she's deciding to bring along these other people? I don't know. So then just to circle this square here, in California, in LA, you might get the public defender's office, but then if you've got a co-defendant, they can't both be represented by the public defender's office because that would be a conflict. So then they have the alternate public defender's office. And if you've got 3 defendants, they both can't have the public defender and the alternate public defender. So then they might appoint them private appointment counsel. Now in LA, you don't have to be a part of it. You can join it. And so there are private attorneys who take cases by court appointment just to kind of fill out their caseload and add to their income by getting fees from the court. It's a set fee schedule though. So that's how that works. But I don't think I answered your question as far as why is her team so robust. If anybody's got some inside track knowledge on that one, please let me know, because I was wondering the same thing. Seems like she's got a heck of a team and she's not paying a nickel for it. All right, let's keep it. I guess all those flipping of homes didn't work out the way that she had planned. Forrest Nelson has been a member for 16 months, everybody. Subscribe, hit the like, share if you can, chat and comment. It's all free. It helps. Thanks, Josh, Tiff, Kaylin, and Wonderful Mods. It's a great point. It's free. If you haven't hit the like button already, we're not going to charge you for it. Go ahead and hit that like button. Heather Cooper Smith, thank you so much for the super sticker. So kind of you. And True Crime in a Minute. Imagine this is coming. Why was W. Lewis allowed to treat Carmen poorly? Learning disability, bringing up her daughter, telling her what she remembers. That question is coming. Where is that coming? It's coming. I know that there was this question. And if I'm imagining things, I promise I will answer it. And that's on Tiffany to remind me. But I know it's coming. All right. Let me keep it rolling here.
Hey Josh, it's Sneemac in Alexandria, Virginia. I need you to explain the social media trial. I know that they're trying to take like a page out of the big tobacco lawsuits of the 1990s, but I just really don't think that there's causation between, the social media use and mental health. It's harder to prove than tobacco being addictive and tobacco causing like people to lose their lungs and stuff. So, and also I think the Communications Decency Act has a strict liability shield for internet companies. They're basically immune from anything, from defamation, negligence, misinformation. I wish they weren't for misinformation, but yeah, I just don't really see where these cases are going to go, because this is just the first out of, I think, 22 cases that are going to be coming out. So just wanted to hear your take on it. Thanks.
Sneemac from Alexandria, Virginia. Thank you so much for calling in. We got the smartest community on YouTube, everybody. I love this question. This case is going on right now, and not a lot of people are talking about it on the YouTubeosphere, or at least not that I've seen. But it's a very important case. And Sneemac is right. It is the first of several. So this is very interesting. There are about 1,600 plaintiffs who are claiming that they were harmed to some degree by social media. And what the court has decided to do is to take 20 test cases. Instead of this being a class action, which is interesting. This is a little bit above my pay grade, how all of this works. But they haven't formed a class yet. It's not a class action lawsuit. The judge has taken 20 test cases that were picked not by the plaintiffs and decided that we're going to put those trials on as almost like a temperature check of jurors and how they feel on this issue. And ask me why that's being done that way. I'm not sure. I should probably get a better lawyer than me on to actually talk us through this whole thing, but that's what's happening. So this is the first case of about 20 that are going to take place to kind of test this issue and see where we all land on this issue. Now, Sneemax makes it another excellent point. I thought they were protected by Section 230, that is the Communications Decency Act, and that they were essentially immune to any kind of negligence or liability. That is true when you view them as simply platforms and that the problem is the content on the platforms. And that has been the argument up until this point. The argument is social media companies are saying, hey, we're not writing all this bad stuff. We're not posting all these things that are making you feel bad about yourself and have all this harm. We're merely a bulletin board. We're merely a platform for other people to communicate. And if you've got a problem with people, go after those individual people, but don't go after us. Now, from a public policy perspective, this makes sense, right? Otherwise, how could these platforms exist if they're going to have the liability for anything that a person said? They're going to be subject to tremendous liability, or they're going to have to self-regulate, and it's going to completely shut down any kind of free speech on these platforms. And they did try that, by the way. They did try a bunch of self-regulation. Remember, we went through a whole period where they were, silencing some people and deplatforming other people, and everybody got mad about it, and they had their own kind of internal fact checkers, and everybody thought their fact checkers were wrong. Depending on the political side of the political spectrum that you're on, you were mad at them for whatever reason. And it didn't work because it was like, well, who's fact checking the fact checkers and all these types of problems. So how do we handle this? This case is designed specifically to get around Section 230. This case isn't saying it's the content that caused harm. They're saying it's the platform itself that caused harm, the delivery mechanism itself that caused harm. And that is very interesting. They're saying that the way you design these algorithms, you intentionally, and it's very important too, they're going after this for what it did to children, because that's important in all of this. What you did to children is you intentionally made this addictive. And you also knew that it was harmful to young folks, and that it caused them to suffer social anxiety, body dysmorphia, all of these other problems. And you were aware of it, and you not only didn't stop it, you actually fed into it by continuing to try to make your platforms more and more addictive. That's a very different and very clever argument. And that's why this case is very fascinating and important. Now, SNEMAC asked the question, well, how do you show causation? How do you show that the addictive nature of this product, it's a product liability case, the addictive nature of this product is in fact what caused the harm? Comparing it to big tobacco, which a lot of people like to do, is interesting, but also not really analogous, because in big tobacco, the product itself was inherently harmful. Tobacco is inherently harmful. Social media is not inherently harmful. Sharing pictures of my kids with my family members is not inherently harmful. Well, depending, I guess, on the family member, but it's not inherently harmful. It's how it's being used by some young folks. And by the way, the vast majority of young people who use social media don't end up with the kind of harm that is being alleged by the victims and plaintiffs in this case. And in this case in particular, the one that's going on in Los Angeles right now, the young woman had a bunch of other issues. She had a very troubled home life. She had all other kind of emotional and mental problems she was dealing with. Even her own therapist said she doesn't know if social media contributed to that or caused that. That's a big problem when it comes to causation. So I could very easily see them losing this case, the plaintiffs. But that's almost kind of the point, is they want to test the waters. So here's a case that might be not all that strong. Okay, they lose on that. And then are they going to, with these other 20 cases or so, kind of change the rubric a little bit and see what in fact does convince jurors? Really interesting stuff, kind of large concept issue, something I'm certainly concerned with. I've got 3 little ones. Oh, thank you, SNEMAC. I've got 3 little ones, and I want to see, them raised in a world where you're fine with protecting them from everything outside of your own doors. But when you have to start worrying about things that are inside your own home that they can access, that really starts to scare you. So very important case here for everybody. Grizzly, Gisela, happy Sunday fun day, Josh, Tiffin, Kaylin, and everyone. I hope you're enjoying your walk, is where if I'm using my powers of deduction. You are either on or returning from a walk, and I hope you enjoyed it. Thank you so much for being here. Good to see you. And by the way, some of the best streaming of the Richins trial, if you want to be watching it, is with Gisela. So please check out her channel. Cheryl has been a member for 12 months. That is 1 year by my calculation. Happy birthday. I'm so happy to be here and a member for 12 months. We're happy to have you, Cheryl. And Farmer's Wife Tupperware. I love that. Thank you so much for the super chat. Tell me where to find that Tupperware too. All right, let's keep it moving here. Here we go.
Hi there, Josh, Tiff, and CC fam. It's Nell from Michigan calling back. First, I want to thank you all so much for welcoming me with open arms, for taking the time to answer my questions even before I get to a place where I can ask the smart ones you talk about, and teaching me so much so that I will be able to ask the smart ones as well. I can see why it's the smartest chat on the internet and why you all say it's the best one. As for my question, I would love to hear your input on a defendant testifying. Over the past year of watching trials through LawTube, it seems to be the universal consensus that it's a bad idea. And for the most part, I can see why. For example, it's my opinion that Banfield might have erased any reasonable doubt all on his own by testifying. But it's also happened where, from my perspective at least, the defendant's testimony won me over. I probably don't know all the problems with it from a legal standpoint, but I could represent some of the more naive members of the jury, and if they could earn my trust, that could matter even more than any legal arguments. As a lawyer, what do you think? Has there ever been a time when you thought a defendant should testify? Or a case where the defendant's testimony changed your mind?
Nell! Oh, I'm so glad to hear from you, Nell. Nell from Michigan. I'm so glad that you called back. I appreciate you asking this question. This is a great question. So what are my thoughts on defendants testifying, and have I ever seen examples where it's a good thing that they did testify? The tried and true thinking on this is it's never a good idea for a defendant to testify. And if a defendant is testifying, that's because something has gone wrong and they're completely desperate, and it's an absolute Hail Mary of a strategy. You got nothing to lose, my friend. Might as well get up there. This might be the last chance you have to have an audience before you go off to prison for a very long time. So go ahead and have your moment. That's usually the thinking behind this. But there are rare circumstances where I think it's necessary. And when would that be? Usually, you see that come up in a situation of self-defense. Why? Because self-defense relies so much on the jurors evaluating what the defendant was going through in that moment. What did they perceive? What did they believe? What were they feeling? Why did they feel that in that moment they needed to do the horrific thing that they did? They're on trial for murder, usually. Why did you feel that you needed to kill this other person in that moment? You're telling us it was in self-defense. Well, rather than just having your attorney argue it, we're going to need to hear from you directly. I think that in the cases where it's rare, and it's even rare in those cases, but in the cases where it's rare, you're usually going to see it in self-defense, because I think if they're going to have a chance, they need to take the stand, stare those 12 people in the eye, and say, I did this horrible thing because of X, Y, and Z. And jurors need to lay their eyes on that person to see whether or not they believe them. Was it reasonable in the circumstances? And even then, it doesn't happen all that often that it's successful. But usually I feel that it is helpful. The couple of cases that came to mind is Raul Valle. You remember this case? Well, this is Ashley Benefield. This is one that came to mind. We'll do Valle first. He took the stand. Now, he's going back to trial, but he's only going back to trial for manslaughter. So he got the murder charge kicked off of this. And I think that however you want to say he performed or did on the stand, it was enough, I feel, to convince jurors that he wasn't guilty of murder. Maybe he's guilty of something, but it wasn't murder. Same with Ashley Benefield. She took the stand, and I felt that she actually did fairly well for herself. I felt that the cross-examination of her wasn't as effective as I thought it might have been. and jurors needed to hear. Now, did they believe? No, you know, you could turn around and say, but Josh, she's sitting in prison right now. Yeah, she's sitting in prison. I think it's 20 years, not life. I mean, and that maybe is the way it should have gone. Maybe what she did was unreasonable, but not premeditated murder. And that's her taking the stand convinced jurors of that. Maybe jurors, and it sounds like they did, thought to themselves, you shouldn't have done what you did, but we understand what you did, and it's not murder. Brendan Banfield sunk himself by testifying. Most people, I think, do. I mean, he's a great example. They don't. It's hard. I mean, Alec Murdaugh. Here's a guy who's a lawyer. The guy spent his entire career speaking. He's a wordsmith, and he wasn't convincing to jurors. And I don't know if he did himself any favors. But I also think that maybe in some of these situations, they've got nothing else left. Brian Walsh, I think, should have taken the stand. I mean, it's funny. It does seem that the cases that we watch have more than their fair share of examples where it might be a good idea for the defendant. But for the vast majority of the time, they shouldn't take the stand. Because I'll tell you, I don't care how smart you are, how good you are in front of people, how convincing you might be, even how innocent you might be. Sitting on the stand with 12 people staring at you and undergoing the crucible of cross-examination is a heck of a thing to do. And if the defendant takes the stand, I almost feel like you can throw out everything else that took place in that trial, because it's all going to come down to that moment. And if that person doesn't come across as completely honest on everything, and even if it's a small thing that makes them look like they're dishonest, that could be enough for jurors to hang their hats on and say, well, I don't believe this person because they lied to me about a small thing. They're probably lying to me about a big thing, or they didn't have an appropriate response or answer for this one little thing. And I'm not believing them on everything. It's a very, very, very difficult thing to do. And you don't see it. You do not see it handled all that well, often at all. Great question, Nell. And I'm very appreciative of you for calling back with that question. Mrs. McGuire has been a member for 5 months, everybody. This place has me so juiced. I love being here. I'm going to say Mrs. McGuire is 78% juiced. Farmer's wife Tupperware, thank you so much for supporting the mods with coffees. Appreciate you. And Heather Cooper Smith, thank you so much again for the gift of a Courtroom Confidential membership. I hope whoever receives that enjoys it. All right, let's keep it rolling here. Where are we at? What am I doing? All right, here we go.
Hi, Joshua. Hi, Tiffany. Eno Hollaback girl here, Kawarthas, Ontario, Canada. It's Thursday, Joshua. I'm just watching the Kouri Richins trial again. Wondering how you feel about Wendy Lewis, the defense attorney, questioning Carmen, who's on the stand today. And I felt that she was hitting a little bit below the belt, and I'm wondering if you thought it was fair game for her to question her low IQ and to also talk about her daughter. I thought that the prosecution probably should have made a few more objections, and I was surprised that the judge didn't interject at some point. My second question is about Nancy Guthrie, and I just saw the latest video from Savannah Guthrie regarding the family reward. I thought it was really odd that they referred to the amount as up to $1 million. That kind of leaves everything wide open in terms of the amount. And I'm thinking, like the tipster or the perpetrator, how much are you actually offering? And how does that work? Is it a cash reward? I know that they have also donated exactly $500,000 to missing kids, but this can't be something that happens instantaneously because they have to investigate to see if the tip is authentic. And also the IRS, Uncle Sam has to have his eyes on it. Rewards are taxable. And I'm just wondering if you could explain how this reward thing.
ANHBG from Kawartha, Ontario, Canada. So good to hear from you. This was the question I knew that was coming and we were waiting for. Yes. Wendy Lewis on the Kouri Richins trial, did she go after Carmen Lauber too hard? Yeah, I think she misread the room. I don't think her tone was especially offensive, but the questions seemed not only to not be effective, but to be offensive. And if they're bothering us, you can imagine how the jurors felt having to sit there in the room as it's happening. And you've got this woman on the stand who, by the way, if you're the defense, you want to make this woman to look to be a liar, right? You want this person to become the bad guy in this whole situation. You got to have a villain in every trial, and it can't be your defendant. So maybe Carmen has to be your villain. Well, you're not doing a great job of making Carmen look like your villain if she's crying on the stand and if she's appearing to be very embarrassed by the whole situation. And I thought it was handled not well. I think that was something that they pre-planned and probably should have ditched that plan in the heat of the moment. Gisela agrees. Oh my God, when she questioned her about learning disabilities, bad stuff. That to me showed, and I don't know Wendy Lewis, and I'm not trying to throw her under the bus, but that to me showed an inability to pivot. Or it showed somebody else is calling the shots in that courtroom, and it's not Wendy Lewis. It might be her client sitting next to her saying, you got to ask this stuff. But, read the room. That's something I say all the time. One of the best skills of a good trial attorney is their ability to have this inert social awareness. Read the room. Is this the moment where you go in after this person, or is it not? Is going in after this person for a learning disability going to play well for you, or is it going to backfire on you tremendously? And I think this backfired. If Carmen had been rude and combative and argumentative and talking about, I'm the smartest person you ever met and blah, 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 maybe then you go, Carmen, did you actually even graduate high school? I mean, what's going on here? You got to get permission from the witness. If the witness is all of those awful things, have at it. Have yourself a field day. Spend all afternoon asking whatever questions you feel are appropriate of this person. But if they're coming across as sympathetic already, find a way to get in and get out. Limit your damages here. And I don't think that was done. And to your question about, why did the prosecution maybe not object enough? Should they objected more? If I were the prosecutor, I would have handled this with kind of indignant objection. Your Honor, are we really, maybe not even a legal objection, but Your Honor, please, kind of stuff, just to let the jurors know I'm as offended as they are, or they should be as offended as I am to how this is all going down. But from a evidentiary perspective, not much objectionable about it. I mean, you're allowed to ask things like, what is your level of education to a person who's on the stand? Jurors technically do need to understand that in evaluating the veracity of the witness. To your question about Nancy Guthrie and Savannah Guthrie's statement about the reward and her saying up to $1 million. I've heard of a lot of people ask about that, kind of zero in on that phrasing that she used. She does talk, if you watch the actual Instagram post, in the language of the post itself, not in the video. She talks about that the $1 million is for the safe return of her mother. So that might be what it's coming from. I have a theory on this thing that it's more about trying to get engagement, to somehow compel engagement out of the person who might have this information. In other words, if you're saying something like up to $1 million, maybe the person who's got that information is asking the same question, like, how do I get the $1 million? And if they're asking that, they might be asking law enforcement, well, hey, I've got information, but how do I get that $1 million? And that might be part of it as well, is to encourage, hey, Well, what do you got? Well, what information do you have? Well, how can you? Well, we'd love to get you that full $1 million, but I'm going to need X, Y, and Z from you, and to kind of, do a little bit of one of these things to try to get some more information out of that person. I don't know. That was just my thinking on it, as well. But it was an interesting way of putting it. And you're right. If anybody's going to get any of this money, it's going to have to be vetted. There's a process. You don't just go pick up a sack of cash because you made a phone call. Dr. Patrice Berry's in the chat, everybody. Thanks for covering this. Hey, chat, about to listen while getting ready for the week. Oh, thank you so much for joining us. Always great to see you. Zarcasm, thank you for the super chat, says, also, how can the defense object to transcripts used by the state when they've already used them as cherry picking and using them out of context? Well, one answer is they can object wherever they want. Doesn't mean it's going to get sustained. Sometimes you make objections because you got nothing else to do and you're trying to make it look like you're really upset with what's happening. But there is a rule about you're not allowed to cherry pick transcripts, right? There is this idea about completeness. I used to love when defense attorneys would cherry pick a statement from somebody on cross-examining. Didn't you say on such and such a date when asked the question X, Y, Z that in fact A, B, C? And I'd be like, okay, fine, have at it. And then I'd get up there and go, you were asked this question, right? And you gave this answer, right? 2 questions later, didn't you get asked A, B, and C and clarify exactly what you meant? So when they asked you that question and it appeared as though you were testifying to such, that's not in fact true. If you read the whole thing just a few lines later, in fact, what you were saying was such and such, correct? Would it have been deceptive to ask you just that one question? Objection, whatever. I made my point. All right, let's keep it rolling. Quiet down, Ritter. Nobody wants to hear these war stories. Derek Sherman, thank you so much. Hey, Josh, I still stand behind my thoughts of the Range Rover guy is involved with Nancy's disappearance. I think the FBI found DNA evidence in the back of the SUV that night, had it sealed, and then towed it away that night. You could be very right. And you're not alone. I felt the same thing. If they pulled somebody over, they had something. They had warrants. They had some information. They did a bunch of testing. They swabbed, I agree with you, the back of that vehicle. It could be that they're waiting on results. It could be, I've said this for a long time, that we could be in a Brian Kohberger situation. That took 47 days to break. 11 of those days, they knew who they were looking at. And it could be that they're just waiting on some confirmation here about somebody that they've already arrested. I agree with you. I thought that was the break in the case, and I'm shocked that we're sitting here now. But it could be that they don't, the last thing they want to do is make an arrest on somebody and not have enough. So maybe that's what they're waiting on. Or maybe they've got a tail on this person. Maybe they've got a wire on this person, and they're waiting for that person to reach out to the person. They believe this person's involved, and they're waiting for that communication to take place. We shall see. But great question, Derek Sherman. All right. Keep it rolling, Ritter. There we go. Well, let me just make sure I'm not losing my place. I did lose my place. See? Here.
Hey, Josh, this is Chris Vogt from Crossville, Tennessee. So my question this week is about the Richins trial, as I'm sure many of us have questions about that. And I was hoping you could talk about what you thought of the cross-examination of the housekeeper, Carmen. From what I've been able to gather as I've been following all this is that the defense seems to stipulate to the fact that Kouri did ask Carmen for drugs, and Carmen did deliver these drugs to Kouri by placing them in various hidden locations throughout their properties, like a random closet and a fire pit. And given that, I guess I'm not really sure where they're going with this, other than Kouri did do all these things. Carmen did deliver the drugs, but it's just a unhappy coincidence that it all happened in the lead up to her husband's death by fentanyl overdose. And Carmen never gave Kouri fentanyl, so she's obviously not involved, right? Sounds kind of absurd, but I can't see what else they're getting at. I hope this finds you well, and I look forward to hearing your insights, as always, on Sunday Funday. Blessings to you, Tiff, Kaylin, and the various assorted Ritter critters, and the rest of the crew. Bye.
Chris from Crossville, Tennessee, one of my dudes. Thank you so much for calling in, my friend. Appreciate it. Yeah, I think your evaluation is spot on, Chris, when it comes to the Kouri Richins defense strategy here. I don't know if they have much of a defense strategy. It's a difficult case for them because she probably did it, everybody. I mean, newsflash on this whole thing. She probably did it. So it's kind of hard to defend that when there's a lot of evidence saying that your client did a really bad thing. So I don't know if they have the most clearly defined theory. But to your point, it does seem like something they would really like to make a point of, and hoping that the jurors will cling to, is the idea that the prosecution cannot put the fentanyl that killed Eric in Kouri's hands. That's like something they want to continue to drive home. They cannot put the fentanyl in her hands. And so Carmen, may have supplied her, but we don't know if that was the drugs or what drugs. This other guy's going to testify. Why am I blanking on his name? The actual drug dealer. He's saying he never sold fentanyl. He's saying he only sold Oxycontin. Robert Crozier. Right. Robert, I never sold fentanyl. I was selling Oxycontin. I love that. How dare you? I wasn't selling fentanyl. I was selling Oxycontin. And listen, to the defense's credit, they're going to try to say that's reasonable doubt. You cannot create a quote unquote chain of custody of fentanyl to Kouri that then gets to Eric. Problem with that is this. The prosecution doesn't need to prove that. The prosecution doesn't need to show in a murder case with a shooting. They don't need to show the defendant possessed a particular gun, right? It would be great if they did. It sure helps, but they just have to prove that person had access to guns, or that person had the means and opportunity to have access to guns, mean, motive, and opportunity to commit the crime. In other words, we don't require of them to show the murder weapon in the hands of the person, because people ditch the murder weapon, and trying to find the murder weapon can be a problem, and trying to trace the custody of something like fentanyl is going to be an issue. I think the prosecution needs to make that abundantly clear, that, listen, what we've proven to you is she was buying drugs. She was buying drugs that she wanted to be extra, extra strong. She was buying them because she wanted to kill her husband. She tried to kill her husband on a previous incident, and that didn't work. So she needed to get harder stuff. Now, whether or not Robert Crozier remembers what he was selling, and whether or not Carmen Lauber knows when that was all handed over, the fact is that all of those people help you establish the idea that Kouri was on the hunt for drugs to kill her husband, and he died because there were 5 times the lethal limit of drugs, and that happened to be fentanyl in his system. She did it. That's the prosecution has to make abundantly clear, while the defense is going to try to say that no. You need to show she had access to fentanyl and she put the fentanyl. No, not the way it works. Good luck to all of them on that. Great question, though, Chris, my friend. All right. Move it along here, Ritter.
Good morning, CC crew. This is Beth R. from Minneapolis again. I'm not sure if this is an appropriate question or not, but I was watching the Kouri Richins trial today, and they had the whole fiasco with showing the undercover cop on camera. So I'm curious if that would have any effect on the trial, or just like how does that even affect law enforcement? Because it seems like a pretty big error to show his face on national, I guess, TV, live streams, whatever you want to call it. Seems like a pretty big error. So thanks for taking my call and happy Sunday fun day to everybody. And I'll talk to you soon. Okay. Bye.
Beth from Minneapolis, thank you so much for calling in. Let's put you on the map. I know this was a big drama. Big boo-boo took place in the Kouri Richins trial, where one of the officers that testified, we find out later, was undercover. He was caught on camera. This was all a big problem. We did take down the video. We removed that part. The videos that we have up right now do not have that officer on there. So we did our job in protecting his identity. Whose problem is this, though? I'm really not going to blame Court TV for this one, or for the pool camera who was ever operating it that day. I'm not going to blame this for this one. I'm not even sure I'm going to blame the judge for this one. I really think this comes down to the prosecution and maybe even that officer himself. You have to imagine that officer being undercover has had a conversation with the prosecution that they are undercover and that they need. I've had this situation happen, and that we've handled that in court, and made the judge aware of it. Even cases that don't have TV cameras, you're going to have this person testifying in court in front of an open courtroom where there might be other, associates of the defendant in court, and we don't want exposing the identity of this person who might have to go back undercover and work in the field again. So how do you handle that? There's a certain amount of discretion that you use, and you don't ask certain questions, and you don't reveal that person's identity or what that person might look like when they are in fact undercover. So to me, I can't imagine this officer not having a conversation with the prosecution. And if the prosecution didn't make that abundantly clear to the judge, and the judge didn't make that abundantly clear to the cameras in the court, there's where the fallout took place. Someone messed up somewhere there. I don't know if it was the cameraman, though. If it was the cameraman, then that's pretty inexcusable if they knew they weren't supposed to videotape somebody and they did anyways. But as far as that effect on the trial, it's a big nothing. It's a big, everybody in that courtroom saw this individual. I mean, it's an open courtroom. It's the only reason you're not putting him on TV is so that he doesn't have further exposure. But anybody in that courtroom saw what he looked like. Yeah, it was just a big mess up. But it's not, she's not going to get any advantage out of it. And the judge, I think, handled it appropriately by not making a bigger deal out of it than needed to take place. All right. Annabelle, thank you so much for the super chat. Says, love the channel. Your integrity and humanity always front and center. Wow, that's very touching. Watching Richins, I wondered if you've ever revoked immunity. No, I have not. Doing that would be fairly drastic. I have pulled an offer for an immunity. I have had situations where I've told a person I will grant them immunity if they give me a proffer, and then we came and proffered them and they lied through their teeth, and I turned to their attorney and I said, first of all, here's a quick war story for you. Proffers are on the record. They are being transcribed because you're essentially trying to get that person to give you information that is truthful that you're then going to use, and you want that locked in. And so we're sitting there doing a proffer, and I can't appear as though I'm trying to coach the person either, or try to get them to give me certain testimony either, because now that ruins the whole point of it. If it looks like the prosecution is trying to influence the testimony by offering them immunity, you can imagine what that would look like in the hands of a defense attorney. So we're asking this person questions, and they're lying to me. And I'm looking over at her. It was a female. I'm looking over at her defense attorney. I'm like, do you want to have a talk with this person? And he's kind of given me one of these. And finally I said, we need to stop this. And I turned to him and I go, this is probably already beyond the point of repair, but if you want to have a conversation with her, I'm not giving her anything. I'm going to prosecute her for murder because she's not helping herself out. And she wanted to stand by her man. Well, she's not standing by him because they're in separate prisons now. So that's the way that all works out. All right. Ann Potter, thank you for being a member for 6 months. Says 6 great months as a CC crew. Josh, your teaching is so clear and concise. Thank you, guys. Love Tea Time with Tiff. Tea Time with Tiff, the hottest new show on YouTube, everybody. Only if you're a member, by the way. Another benefit of membership is Tea Time with Tiff. All right. All the members, she's telling me, all the members. And Heather Cooper Smith, thank you again so much for the super sticker. All right. Let's get to our next question here.
Hello, Josh. This is JC Broadway from Salt Lake City. I have to be fast because I got cut off the first time I tried this, but my question for you is, are you in the mood for a bar exam sample question? Because that is what is happening here from the California State Bar Exam Guide, so no pressure. Josh, here we go. Here's the question. Listen closely. A security guard at a retail business hatched a scheme in which he would disable a security camera and then leave the door to the business office unlocked so that an accomplice could enter, force the safe open, and steal its contents. The next day, the security guard ended his shift and left the door to the business office unlocked, but forgot to disable the security camera. Big dummy. That night, the accomplice entered the unlocked business office, but was surprised to see the business manager inside. The accomplice then struck the business manager with a paperweight and emptied the safe. The accomplice was arrested shortly thereafter and immediately confessed, implicating the security guard. The security guard was arrested and charged with burglary. At a trial in federal court, the prosecution offered an unaltered digital copy of the videotape taken by the security camera on the night of the burglary. The security guard objected, claiming only that the original videotape had to be produced. How should the court rule on the objection? I shall leave your options in the next message.
This is great. This is a perfect law exam question. Hey, it's me. Thank you, JC Broadway from Salt Lake City, Utah. What I love about this is that the first 3/4 of that question are not important at all. And that's what they do, is they throw a bunch of facts at you that you think might be important, but none of them are important. What's important here is that a videotape of the crime was used and it was a copy of the tape. That's the issue we need to dissect. All right, let's get to our options.
Here are your options. A, the court should overrule the objection because digital copies of an original are admissible per se. B, the court should overrule the objection because the security guard did not question the authenticity of the original videotape. C, the court should sustain the objection because the digital copy is not the original. D, the court should sustain the objection because the original videotape is the best evidence of what occurred. Or E, this issue would be moot because VCRs aren't available anymore. Just kidding, I just threw that one in there. Your options are A, B, C, or D. I will call back with the answer.
All right, I'm going to let you guys all guess. I want to see your answers in the chat. I'm going to play the options one more time while you're all guessing.
Here are your options. A, the court should overrule the objection because digital copies of an original are admissible per se. B, the court should overrule the objection because the security guard did not question the authenticity of the original videotape. C, the court should sustain the objection because the digital copy is not the original. D, the court should sustain the objection because the original videotape is the best evidence of what occurred. Or E, this issue would be moot because VCRs aren't available anymore. Just kidding, I just threw that one in there. Your options are A, B, C, or D. I will call back with the answer.
We are all over the map. I'm seeing A's, I'm seeing B's, I'm seeing C's. I'm seeing mainly B's and C's. Shy Gal says C. Zimmy123 says B or C. MBW says C. All right. So A says Ashley Floyd. So it sounds like we're A says moments in trading. Sounds like, though, for the most part, we're looking at B's and C's. All right. Drum roll, please. The answer is oh no. What did you know why? Kaylin? Yes. This was finally not my fault. For the first time in the history of the channel, this one wasn't my fault. All right.
And the correct answer is B. The court should overrule the objection because the security guard did not question the authenticity of the original videotape. An original writing, recording, or photograph is required in order to prove its content unless the federal rules of evidence or a federal statute provides otherwise. This best evidence rule applies not only to documents, but to recordings, including audio and video recordings and photographs as well. However, a duplicate is admissible to the same extent as the original unless a genuine question is raised about the original's authenticity or circumstances make it unfair to admit the duplicate. Here, an unaltered duplicate of the original videotape was offered by the prosecution, not an inverted Sally Port video. The security guard offered no evidence challenging the authenticity of the original videotape or suggesting that unfairness would result if the copy was admitted. Therefore, the digital copy is admissible and the objection should be overruled. So there you have a little lesson in best evidence. Thanks for playing, everyone. And Josh, call me back. Thanks. Bye.
JC Broadway from Salt Lake City, Utah. This was a great question. So what this question is the what's called the best evidence rule. You may have heard that referred to before. All that rule is really about is ensuring that documents, videotape, audio recordings are reliable. Okay. Well, how do you do that? One, you have the original. So if you have the original of a document, that's important to have. The original of a piece of video, original of a piece of audio, all of those things are important. But we also realize that we live in a world where that's not all that much entirely possible to have originals of things. And most of the time, what we have are copies of things. So because the rule is designed to present against fraud, alteration, inaccuracy, what we're looking for is where somebody took a document and manipulated it. They took audio and they cut something out. They took video and they AI'd it all up. How do we ensure against that? Well, we, for the most part, if it's being provided and it's video, but it's a digital copy of that, we're going to say that's fine. Or it's audio and it's a digital copy, we're going to say that's fine. If it's a document and it's a photocopy, we're going to say that's fine, unless there is some question as to its reliability and authenticity. So, as to question B, had they raised the issue that this is not authentic, that this is not reliable, then the judge could have made a determination. Okay, well, where's the original? They're saying this has been manipulated. They're saying this video has been altered. Where's the original? And that's where the best evidence rule would come in. But you don't get to just make the objection because it's not the original, because that's the world we live in. The other important thing to understand about this is it only comes up in situations where it's the content of the document or thing that's at issue. So it's the things taking place in the video, the things taking place on the audio, the actual words inside of the document that are important, where this might be an issue. So anyhow, very something you don't see all that often. I'll be honest with you. Usually every single piece of evidence in court is a copy, and maybe sometimes a copy of a copy, because that's the world we live in. But every once in a while, you'll see it come up where they're questioning the authenticity of a document. I saw it I had one situation where the issue was not an alteration, but that the copies that were in evidence were so poor that we couldn't read certain things, and they felt that was important, therefore, to have the originals. And this was so long ago, I can't even remember how that all worked out. But that was like the only time I think I've ever experienced the best evidence rule. Anyhow, if you got it right, give yourself a pat on the back. And if you got it wrong, you're probably like most lawyers. Dr. Patrice Berry just became a YouTube member, everybody. Thank you, Dr. Patrice. We're so honored by that. Thank you. Ezza just gifted a membership to somebody, so I hope you enjoy that. Humankind has been a member for 3 months, everybody. Honored, glad to have found you. Oh, well, we're glad that you did find us, and we're happy to have you. All right. All right. It's that time. Our last 3 questions, everybody. We've had a good day, though, right? We got a bar question out of it. We talked about Kouri Richins. We talked about Anna Kepner, Guthrie case a little bit. We've been all over the map, all over the world. You guys are all fantastic. Let's see who's bringing us home with these last few questions here.
Happy Sunday Funday, Joshua, Tiffany, Kaylin, the greatest mods on the whole planet, and CC family. It's Alicia K. Mayo in Humboldt, Tennessee. Oh, Joshua, this is basically in your backyard, and, well, you are the greatest person to ask any question regarding the law, at least in my opinion. The California pedophile who was recently granted elderly parole, Newsom says there's nothing he can do about that. Is that accurate, what Newsom says? And if it is or it's not, can you explain that further? I appreciate it. And I'm going to go for a bonus question. CrimeCon's coming up, Joshua. Who are you most looking forward to seeing there that's not CC related? And if y'all are going to CrimeCon, remember that 10% discount code of Courtroom, all capitalized. Hope y'all have a great Sunday Funday. Thanks. Bye.
All caps, all one word. AKM from Humboldt, Tennessee. Thank you so much for showing up every single week. Thank you so much for asking the question. Yeah, this is a horrific case situation here in California involving the concept of elderly parole and a man by the name of David Allen Funston. I mean, just taking a look at it, this guy is not somebody you would want back on the street. But why is Newsom saying that he can't do anything about it? I thought he's the governor. I thought he can do anything that he wants, and he usually tries to. Well, some questions I feel like I can answer, and others I feel like I need a little bit of help. And this one, I felt like I needed to phone a friend.
In California, the governor has limited control over the parole board. For example, on murder cases, the governor has limited discretion to overturn the decision made by a parole board. However, on non-murder cases, including cases involving conspiracy to commit murder, rape, child molestation, the governor has no discretion to overturn the parole board's decision.
There you go. That is my friend Eric Siddall. He is currently a practicing prosecutor in the LA District Attorney's Office. I've known him for 20 or something years now. He is also one of the very few people cross-designated to work as a prosecutor in the U.S. Attorney's Office as well, and a good friend of mine. And I like that sweater of his. It looks like he's about to go rob the Louvre when he's done answering our questions. So thank you for that, Eric. The answer is the governor can only do certain things when it comes to parole board recommendations, but that's not the end of the story when it comes to this person right here, David Allen Funston. First of all, let me tell you what he did. Back in 1996, he was convicted for several counts of kidnapping and the R word of children ages 3 through 7, ladies and gentlemen. He is a horrific, evil human being. The judge at the time, in fact, in sentencing him, said that he is the monster parents fear most. This is a person there should never be a reason we would ever want him walking the streets again. And the judge felt so too, because at the time he was sentenced to 3 consecutive 25 to life sentences. By everyone's estimation, this person should never be walking the streets again. So why are we even talking about this? Well, in their infinite wisdom, the legislature of California decided in 2017 to pass a law called the Elderly Parole Program. And doesn't this sound great? The Elderly Parole Program. And what they said is that when people are 60 years old in prison and they've also served 25 years, isn't that a long time? 60 years old and 25 years in prison, that they should be granted the ability for parole. Then in 2020, they said, well, that's not good enough. 3 years later, they say, you know what? 60's too old. We should make it 50. 50 years old and not 25 years that you have to serve, only 20 years. This is a law on the books in California. If you are 50 years old and you've served 20 years of your sentence, you are going to become eligible for parole for certain crimes, I should say. It doesn't apply to all crimes, not to LWOP or death penalty crimes, but to certain crimes, and his crime is one of those crimes. It is, our legislatures used to be full of lawyers, and they used to be full of people who had some idea of kind of on the ground how the criminal justice system works. They are so far removed from any of that. Most of these people are people who've never held a job and are just kind of career politicians, and they come up with what they sounds like great ideas. And then you get, how is it in practice? And here you go. Now you've got a person who kidnapped, and the R word, children 3 through 7. He was luring them with, I think, toys and candy. He has served his 20 years, though, and he is over 50 years old. And so he is, according to the parole board, recommended for parole. And Newsom, it is correct, can't do anything about it. He could have done something about it back in 2017 and 2020 when these laws were being passed. He could have probably alerted people to what a bad idea that this could be, but he didn't. But that's not where this ends, and thank God. The California Department of Recommendations has actually turned him over to Placer County, where these crimes all took place, because, by the way, interesting, these types of crimes against children also have nearly unlimited statutes of limitation. So they found another one, and they're going to go ahead and charge him with that. They've got new warrants, new criminal complaints, and he's going to get new charges, and they're not going to let this person go anywhere. But are there other people like him similarly positioned that they might not have that same opportunity? Who knows? If you're in California, maybe write a letter. Pretty remarkably breathtaking. Oh, we didn't see these consequences type of legislation. Let's talk about CrimeCon, though. Thank you so much for bringing that up. AKM, yes, we are going to CrimeCon. We're excited about it. It's coming up quick. We're already in March, everybody. But on May 29th through 31st in Las Vegas, Courtroom Confidential is going to CrimeCon. We're going to have a booth. We're going to be doing speaking things. We're going to be doing meetups, all sorts of fun stuff. We've got a discount code for you, 10% off at checkout. And who am I looking forward to? Well, I'll tell you people who I know are already confirmed and going. There's some folks who I think are still working on it, and I don't want to speak for them, but my good friend Derek Levasseur is going to be there. I'm really looking forward to hanging out with him. He's a great pal and a very, very accomplished and smart YouTuber and true crimer. My buddy Joe Scott Morgan's going to be there. Always love talking to him. One of the smartest on forensics in the entire business. My buddy Matt Murphy will be there. I'm looking forward to hanging out with him a little bit. But if I had to pick one person, I'm really excited this year. I don't know him. I'd love to meet him, and I'd love to hear him speak, is going to be John Douglas. This is the guy. This is the man. This is where this whole kind of forensic profiling started with. He's got an incredible backstory. You guys should check it out. If you don't know about him, you should know about him. And I'm really looking forward to seeing this man at CrimeCon. All right. He is the guy, says Kaylin. That's very true. So, and we'll be there. You said I couldn't pick a Courtroom Confidential person, but we're going to be there too. So it's going to be fun. We hope to have you all there as well. All right. It's our last two. What happened here? Who's bringing us home? Here we go.
Hi, Josh. This is Jenny from Inwood, West Virginia. I have a random question about the O.J. Simpson case, specifically Mark Fuhrman. I've seen answers to this question go both ways on the internet. Can't read everything, can't trust everything you read on the internet. But did Mark Fuhrman have to plead the fifth to every question that he was asked? Or could he have pled the fifth to some and not others? If he could have pled the fifth to some and not others, what could have opened up because of that? Like, would any doors have been opened because of his answers? Just curious. Thanks so much for what you do. Bye.
Jenny from Inwood, West Virginia. Thank you so much for calling in. Let's put you on the map. Interesting question. Yeah, this is something that comes up every once in a while. I'm glad that you asked it. We see this in other examples. This was an interesting thing that happened with Mark Fuhrman, though. So, a little background. Mark Fuhrman, obviously a very controversial figure during the O.J. Simpson trial. There were allegations that he had used incredibly inappropriate language. He had denied that on the stand. Then the defense uncovered audio tapes where he had, in fact, used that language that he had denied ever using in his life. And they wanted to impeach him with it. Well, they had a hearing outside of the presence of the jury. That's what a lot of people don't remember about this, is that when he was pleading the fifth, it wasn't in front of the jury. And I think it's because the judge knew that might take place. But what the judge did do, which is kind of interesting, is rather than Fuhrman, through his attorney, saying, I'm not going to testify because I'm going to plead the fifth. And why was he pleading the fifth? Well, it had to do with possible perjury charges. He had already said, I never said that word in my whole life. And now they've got him on tape. So if he's starting to admit that, in fact, he did say it, would that subject him to perjury charges? But instead of allowing him to do that, the judge actually required him to take the stand to actually plead the fifth, which is a bit of theater, which was interesting because, one, why was he making him do that? And two, he's doing that in a courtroom with no jury, but with cameras. So the world got to see it, but the jury potentially did not. A lot of interesting decisions being made by the judge on this situation. And then, instead of just making him take the stand and they ask him a question and he says, I plead the fifth, usually a judge will end it there. The judge may turn and say, is your intention to plead the fifth to every question asked? Yes, it is. Okay, I'm not going to go through the theater of all of this. But they allowed him to ask several other questions, and he pled the fifth to all of those, including, I think it was something along the lines of, did you ever manipulate or plant evidence in this case? And he said, I plead the fifth. And everybody lost their minds because now it looks like he may have done something like that. Okay. Why did he plead the fifth to every single question? Well, his counsel advised him to do that. And that's what attorneys are going to do because of the issue you point out, Jenny, that it could open the door to other issues. One, a concern is if you aren't answering some questions, but you are answering others, is your entire testimony going to get thrown out because you're not allowing for a full cross-examination because you're only answering some stuff and not others. That's not the way that usually works. Not so much of a concern here because it wasn't in front of the jury, like I said. But there is the concern that if he answered a question and that question was close enough to the questions where he actually does have a Fifth Amendment interest, would he be viewed as waiving his Fifth Amendment protection and be compelled under threat of contempt to answer the questions that he had already pled the Fifth to? Now, that's usually why you don't have them just sit there and plead the Fifth to everything. But the way it came across is as if he had committed crimes on every question that he had been asked about, which was not in fact true. The whole issue was about the perjury thing. So that's how it all played out. Probably should not have played out that way. It created big, kind of hullabaloo that we're still talking about to today, but that's why his attorneys told him. By the time he was doing this, by the way, he was cooked anyways. So, reputationally, career-wise, everything else. And his attorneys were like, well, the last thing I'm going to do is have you actually admitting to perjury on the stand. All right, everybody. It's that time. Derek Sherman, thank you so much for gifting a membership. Appreciate you. Freckle Feet Kitties has been a member for 2 months, everybody. Ditto Ray Fab Tiffin Mods. Appreciate that. Beach Bum has been a member for 13 months. Happy Sunday Fun Day, everyone. All right, here we go. Who's bringing us home today?
Hi, y'all. Court Dog Daniel here from New Britain, Connecticut. Attorney Ritter, my question is about Colin Gray, who testified on his own behalf on Friday. A lot of people are focused on the precedent of charging a parent with murder instead of something like reckless manslaughter, as in the case of James and Jennifer Crumbly. But here's the nuance that I'm curious about. If the state is charging his son, Colt Gray, as an adult, while charging Colin based on his legal responsibility for a minor, is there a built-in contradiction in pursuing those two theories at the same time? And more importantly, could that create any downstream appellate issue if Colin were convicted? Or do these prosecutions sit entirely separate as independent legal entities? Thanks as always. Juiced!
I can't get that through that with a straight face. One of my dudes, CDD from New Britain, Connecticut. Thank you so much for asking the question. I've actually heard this question. For a couple of you asked it. It's a great question. Shows you how smart all of you are. It is a very nuanced question. So, Colin Gray is the father of Colt Gray. He's being put on trial for his role in supplying weapons to his son, who is obviously very troubled. And I don't mean to put it lightly by describing him as troubled, because then he went on to commit an unfathomable atrocity by shooting at his school and killing fellow students. He's on trial for murder as an adult. Colin, his father, is on trial for his role in that murder, but also for his role in, and I forget the term, but Daniel just referenced it, for his I don't know if it's suborning a minor or assisting a minor in the commission of a crime or something like that. So how do you have it both ways is the question here. How do you have it where you're saying for the purposes of his crime, we're going to treat Colt as a minor, but for the purposes of Colt's crime, we're going to treat him as a adult? Is there some sort of built-in contradiction there that will cause problems on appeal? And the answer is no. Will they make an issue out of it? They might, but I don't really think it's an issue at all, because his crime was committed at the time that he supplied the weapons to his son, and at the time that he didn't get his son help, for the same kind of arguments of the Crumbly case. That was a completed crime there. Just because down the road, the legal system and the prosecutors have made independent decisions on how to charge Colt doesn't change the status of Colt as a minor at the time that Colin committed the alleged crimes, if that makes sense. So one is when the crime was committed, and another is a filing decision being made by prosecutors independent from Colin. But this is another one of those very fascinating cases where you have a parent on trial for murder for the actions of their child, as in the Crumbly case. And I got to tell you, I'm a little bothered by it. I'm a little troubled by it. Not because I don't think we should do something to stop these cases, and not because I don't think that these parents share culpability, but do they share criminal culpability? That's the question. And at what point do we draw that line? I'm not saying that we never draw the line, but we're getting on really slippery slope type territory here when you are asking to hold somebody criminally responsible for the independent actions of another person. This is not a conspiracy theory. If Colin were sitting in a car outside of the school to act as the getaway driver for Colt, we wouldn't even be talking about this. That's a clear conspiracy situation, a clear aider and abetter type situation. Here, there's no allegation that Colt said, by the way, Dad, where's the gun? I'm going to go out and kill my fellow students today, my fellow classmates today. Okay, have fun, son. This was independent actions of another human being. But we're saying you should have known better and you should have parented better. And I agree that he should have known better and that he should have parented better. But does that make what he did a crime? In the Crumbly case, they said, yeah. They said, yeah, that your crime was in having a troubled young person and then supplying that young person with a gun and then not properly securing that gun. That is enough. That is enough consciousness and disregard for the safety of others that we're going to say, like we talked about degrees of murder, that's a second degree murder. And that's the argument that they're trying to make here with Colin. And again, I'm not even saying that it should never happen. I'm just saying we're getting into really uncomfortable territory for a person who practices criminal law their entire career. We like clearly defined lines. And these are getting into very gray territory. No pun intended. Thank you guys so much. Great questions. Don't go anywhere. Don't touch the buttons. Don't leave. Don't go do whatever you got to do on a Sunday. I'm sure it's very important stuff, but just give me a few more minutes to give you guys some quick announcements. First of all, I want to tell you about our website, thecourtroomconfidential.com. We put a lot of work into it, and here's the big 3 M's that you can find on it. First of all, if you listened here today and you enjoyed yourself and you thought you answered a bunch of questions, Ritter, but you didn't answer my question, well, the way that you can solve that problem is by leaving us a question, leaving us a message at thecourtroomconfidential.com. Click on leave us a message, and I will answer your question at our next Sunday Funday. Membership. If you saw people getting gifted memberships, if you saw people celebrating their birthdays of membership, how do you become a member? You go to thecourtroomconfidential.com and click on become a member. And you could do it right now. You could do it live during the show, and we'd let everybody know what a wonderful decision you made. So go to thecourtroomconfidential.com and click on become a member, and you can become a member right now. Merch is the last of our 3 M's. If you click on the shop, you can find out all our t-shirt options available, including this shirt that I'm wearing right now. We've got a bunch of other colors. We've got mugs. We've got tumblers. We've got pajama pants. We've got zip-up hoodies. We've got quarter zips. We've got everything. We've got you covered. Please click on the shop at thecourtroomconfidential.com. Quicksilver Fox. I'll take that, says Lee Hillard. Oh, we've got hats, too. I got to wear one of those hats one time while I'm doing this. My first fun day Sunday, says Carol Sand. Welcome, Carol Sand, to your first Sunday Fun Day. What did you miss this week? Well, we had our weekly roundup. That took place on Friday. We talked about Nancy Guthrie, Kouri Richins, Tyler Robinson. The weekly roundup is kind of our show that rounds out all the shows. Everything that happened this week. What did you miss? If you don't have the time to watch everything, then just at least watch the weekly roundup, and we've got you covered. Also, on Fox Nation, we had the latest episode of the weekly Rap Sheet. Kind of doing the same thing, except I'm co-hosting that show along with my friends Paul Morrow and Donna Rotuno, talking about, we talked about the social media case quite a bit. We talked about Kouri Richins and a bunch of other stuff. So please check that out. It's up on Fox Nation right now. And you, unless you were a member, may have missed our members only live stream for the month of February. We had a really good time. It was fun. We had a lot of laughs, showed some behind the scenes stuff. That is for classified membership levels and above. If you are, please go check it out and watch it if you didn't watch it already. And we would love to have as many of you join us at our next members only live stream for March, coming up soon. Finally, stay tuned. All next week, the Kouri Richins trial is going to be live streamed. Thank you for the ad-free stream, says a therapist you know. And thank you for mentioning that. Live streamed on Courtroom Confidential live trials. That is on our sister channel. So please go subscribe over there so that you can join everybody, all of your friends in the chat to watch that every single day next week. Then on Monday, we've got a couple of really cool guests coming up for you. Monday, our guest is going to be Paul from Reporting Live from My Sofa. He's always a good time, talking about the Kouri Richins trial. Star witnesses testify. That will be live at 5 p.m. Pacific, 8 p.m. Eastern. Join us for that tomorrow. And then on Wednesday, we're going to have Joel Waldman from Surviving the Survivor, fresh off of his recent vacation, talking about, again, week 2 of the Kouri Richins trial. And then Ruth Miller is having a bench trial, if you didn't see. That starts on March 3rd. Thank you for that, Dr. Patrice. And then that's Wednesday. So that'll be live again at 5 p.m. Pacific, 8 p.m. Eastern. I already told you about CrimeCon, but I'll tell you again. It's coming up in Vegas, May 29th through 31st. Use the discount code Courtroom, all in caps, all one word, at checkout for 10% off. Big thank you to my friend Eric for joining us with our Phone a Friend today. Appreciate you, Eric. Big thank you to Afton and Sonia and Kathy and therapists you know for being the best mods on the entire interwebs. We appreciate you. Big thank you again to Debbie Harrow for the super chat. That was so kind of you to kick us off that morning and very, very generous. Appreciate you. Nate says, and I still don't know how to change my membership. I don't have an iPhone when I emailed Josh the other day. I think you can do it online. I think you can figure it out. We'll figure it out for you somehow, but appreciate you, Nate, for asking. Finally, thank you to Kaylin. Kaylin, there you are. And thank you for taking responsibility for that one technical error today. That was not my fault. In fact, I just wanted everybody to see that. She's going to yell at me for this later on. How dare you? How dare you in front of everyone? Tiffany, you're the best thing that ever happened to me. You guys are fantastic. We will see you all here tomorrow night. Take care, everybody. Bye-bye.